Hello, my name is Madeline Gauthier, co-founder of the Cannabis Law Digest and a member of the CWCBExpo Advisory Committee. I'm thrilled to introduce our next CWCBExpo Insider session, update on landmark petition filed with the Supreme Court to declare the federal criminalization of cannabis unconstitutional. While the Supreme Court ultimately decided not to hear the appeal, the case challenged the constitutionality of the Controlled Substances Act and its misclassification of cannabis as a Schedule I drug. This case is expected to set the stage for the next phase of the legalization movement throughout the US. And this case, as it has progressed throughout the courts, is one that we have featured in the Cannabis Law Digest. Moderated by Politico's Mona Zhang, the panel highlights the next steps towards legalization, as well as several issues that the case highlighted. Listen in as Mona Zhang speaks with industry trailblazers Lauren Rudick, Joseph Bondy, and Michael Hiller, the lawyers who handled the case pro bono, as well as one of the plaintiffs, Leo Bridgewater of the Cannabis Cultural Association.
My name is Mona Zhang. I'm the state's cannabis policy reporter for Politico, and I'm really excited to be moderating this panel today. We have Michael Hiller, who is the principal at Hiller PC. He was the lead attorney in the case Washington v. Barr, which is the lawsuit challenging the constitutionality of marijuana's federal illegality and the topic for today's discussion. Also joining me are Lauren Rudick and Joe Bondy. They're both part of the attorney team for the case, and Leo Bridgewater, who is a cannabis advocate and one of the plaintiffs. So to start off, I was hoping, Michael, you could sort of just give us a brief overview of the case and tell us how, things got their way to the Supreme Court.
We've essentially challenged the constitutionality of the classification of cannabis under the Controlled Substances Act on essentially two grounds. One, we said that the law on its face was unconstitutional, which means that it's unconstitutional as to everyone. And the second part of the case that we brought was that we said that even if it's not unconstitutional to everyone, it's unconstitutional as applied to certain groups of people. And those two sort of aspects of the case could be broken down into various parts of the Constitution and why it is that the Controlled Substances Act violated it. But that's sort of the gist of the case. We filed the lawsuit in the Southern District of New York. And essentially what we argued, it was unconstitutional on its face based upon the fact that all laws in the United States have to make sense. We don't all have to agree with them, but they all have to make sense. And we argued quite simply that based upon the facts and the evidence as we were able to marshal it, proved without any real doubt that the law governing the designation of cannabis is unconstitutional because it's completely irrational. And then we brought a series of as-applied challenges, and those as-applied challenges really pertain to medical use and how those who take cannabis as a medicine really are restricted from, among other things, from being able to travel to Washington, D.C., to advocate in support of legalization and other civil rights they might support. And so we argued that the designation of cannabis under Schedule I of the Controlled Substances Act violated the constitutional right to travel, violated the constitutional right to free speech. And then we had a separate argument that the laws pertaining to cannabis and basically criminalizing it have been inequitably applied and raised substantial equal and social justice concerns, specifically that persons of color are 3.5 to 4 times as likely to be prosecuted and convicted under the Controlled Substances Act as white people, even though both groups use the cannabis in similar proportions. And so that was essentially what we argued. And regrettably, the Southern District concluded that if we wanted to make any arguments about descheduling cannabis, we first had to go to the DEA to file a petition. And under the Controlled Substances Act, I know this is a long answer to your question, but it's the only way to get there. Under the Controlled Substances Act, there is a petitioning process, but we argued on multiple grounds that the petitioning process really doesn't provide appropriate relief. But the most important one was our argument that the DEA's position is that they have no power to deschedule cannabis. According to the DEA, they can't go any lower than Schedule II, which doesn't help anybody. So we went to the Second Circuit. We appealed when the court dismissed our case. And the Second Circuit actually reinstated the complaint. But the Second Circuit also said, we want you to go to the DEA anyway to file a petition. Well, the concern that we had, Mona, is that if we were to have filed a petition with the DEA, they could have actually rescheduled cannabis under 2. And if they had rescheduled cannabis under 2, that would have rendered every single cannabis business in the United States basically illegal, or almost every cannabis business in the United States illegal. And that would have resigned, those who treat with cannabis to the black market. We didn't want to do that. So we informed the Second Circuit that we were going to the US Supreme Court. And so we filed a petition. And although we got unprecedented support from multiple groups, 19 groups, 2 cannabis scientists, and 7 members of Congress, the US Supreme Court unfortunately did not accept our petition for review. And so that's sort of the beginning and the end of the case.
Why do you guys think the Supreme Court didn't choose to take up the petition?
The Supreme Court was anticipating a very full docket in anticipation of some election disputes. And it was a tough time, with the loss of Ruth Bader Ginsburg and adding Amy Coney Barrett to the court. Just a transitional time. I don't think it was, timing is everything. I don't think that from a timing perspective, our petition was going to have the best chances for success. But the Supreme Court had such a unique opportunity here. It really didn't matter, what political alignment any of the justices had. There was something in this case for everyone. So it was a big missed opportunity. And, we're still looking forward to pursuing the case down additional avenues in the future.
We were in good company, though. We lost with 158 other litigants that day. It wasn't that we were in poor company. And I think there's a lot of elements to this movement. And it was very positive for us to see the support across such a wide spectrum of groups and even among elected officials in this case. I think we really moved the needle in other ways. And like I said, we lost in the best of company, and it was a very difficult row to hoe anyway in terms of being heard. So I feel like we won a lot of net positives notwithstanding.
Leo, what did it mean for you as an advocate to be involved with this case?
Well, to be quite honest with you, this case has been the gift that keeps giving for me. As you know, I'm actually living in Trenton, New Jersey, and having had that decision happen, a couple of weeks, if not a week and a half, right before we voted for adult use here in New Jersey, it helped forward that conversation as to what is this going to look like, because it passed overwhelmingly here in New Jersey. 67% of the vote, almost 2 million people voted yes on question 1. And so, if you look at everything that's happening here, it's a microcosm. I mean, it would have been beautiful for this to have for the Supreme Court to be actually reviewing this case, going into election day. But being that you have 5 states who voted for adult use or medical in some way, shape, or form, even 1 state voted for both adult use and medical on election day, it's the ripple effects has been mighty. I mean, they're even talking about voting for some sort of a measure in the House next month in December. And I believe, my heart tells me that, when you look at the work that Lauren, Joe and Mike put in, I believe that, this case was the catalyst to get that going.
There are teams of lawyers in New Jersey. I know of one team, and also in Connecticut, who've taken our brief, literally taken these words of Michael's and put them into these pleadings of theirs for their own courts of appeals. And so we really heightened a lot of people's awareness by what we're doing. It's really gratifying as we watch it unfold and as it keeps giving.
Why do you guys think that the courts are a good way to pursue policy reform, particularly marijuana policy reform?
They may not be. They may not be.
I would say this, from a legal perspective, it's really for the courts to decide what is and is not constitutional in our constitutional framework. It's for the courts to make those determinations. It's not for Congress, for example, to catch itself. It's for the courts to oversee Congress when it comes to the constitutionality of statutes. So that's the legal response. Then there's a practical response. The fact is that the 7 members of Congress who submitted an amicus brief actually stated in the brief that they considered legalization legislation a practical impossibility. And so from a sort of a practical perspective, it's very, very difficult to move the needle in Congress. So that is a second piece. And I guess from an administrative perspective, we know that the DEA will not reschedule, or I say deschedule cannabis, because the DEA's perspective is that it can't. So really, it's not only that the courts are the best mechanism, but they may be the only mechanism.
I think people have a rare opportunity in many ways to contest the marijuana laws. If we are right, and I submit we're very, very right about marijuana and it being improperly scheduled, then a number of things have to change. And it's really amazing to see that if we keep pushing this movement, we're going to continue to affect change. And one day we'll reach that tipping point, I think.
I do think it's important for our viewers to understand when we say we're right, and we're right about the irrationality of cannabis being classified as a Schedule I drug. And just to take a step back, in order for drugs to be properly classified as a Schedule I drug, they have to meet 3 requirements. They have to have no medical purpose. We know that's not true. They have to be highly capable of abuse. We know that's not true. And then they can't be used safely even under strict medical supervision. And we know that's not true. So that's the rationality that we're challenging in this case. And I think that's what's resonating with most people, is just, how did this drug ever get classified as a Schedule I substance in the first instance? And when we started to dig into it, we realized it was rooted in racial animosity and a desire to suppress political rights as opposed to do with public safety. And the Controlled Substances Act is supposed to protect public safety. So that's when we say we're right, we know we're right, and everybody is catching on because it's just so obvious.
From a local level or state level perspective, right now, today, yesterday I testified and sent an assembly committee for New Jersey's adult use bill. We were talking about social equity, the whole 9 yards. Yesterday, I testified. Today, I've been talking to a lot of state assembly folks. This case it came up every single time I talked to someone. Okay, so I could imagine that this is something that, whether they're admitting it or not, from a state level perspective, as these states start to legalize for adult use and they do their research, that people are finding out that just how close cannabis actually came to becoming federally legal. And when you look at all the details that went into it, particularly having all those congressmen attach amicus briefs to this case, it's reverberating throughout the country, at least here in New Jersey.
It's one part of the case that very few people know about, and that is just how close we came. At a very first hearing, we went to the court and we asked for what's called a temporary restraining order, which basically is a request that the law be suspended for a limited period of time for a particular purpose. And in this instance, we asked for a restraining order to prevent the law from being enforced, so that one of our plaintiffs, Alexis Bortell, could go to the halls of Congress and meet with several members of the House of Representatives who asked to meet with her to discuss the Marijuana Justice Act, which had just then recently been introduced. What was interesting is the court initially said no. It wasn't more than maybe, a minute or two, Joe Lauren, before the judge just said, I'm not granting that relief. But then he did say, but I'll give you a chance to make your record just so that you have something on the record in case you want to file an immediate appeal. And so we expected to have maybe 5 or 10 minutes. But what happened was the judge gave us almost 2 hours of argument. And during the argument, it became, I think, much more clear to the court that we had a much stronger case than initially anticipated. And at the conclusion of that argument, rather than the judge just saying, okay, I'm denying the TRO, the judge actually said, I'm going to reserve decision. And then he retired to the side of the courtroom for a good 15 to 20 minutes as he debated the issue with his law clerks. In the end, the judge did deny the TRO, but then he immediately said that he was going to schedule a trial within 6 months and deny the Justice Department's motion to dismiss. And that was a thrilling moment for all of us. All we have ever wanted in this case was just one opportunity to question a member of the Justice Department or the DEA on the classification of cannabis, because Lauren is 100% right. It's not that the Controlled Substances Act and cannabis are not aligned. It's not that cannabis meets 1 or 2, but not 3 of the required elements for designation as a Schedule I drug. It meets none of them. I mean, just think of the first one, that the cannabis has to have no accepted medical applications in the United States. Right now, there are, 43 jurisdictions that recognize it for medical purposes? That's almost 80% of America. if you can include the territories. So we wanted that opportunity, and we were thrilled that we were going to have the opportunity to try the case. But here was the rub. About 2 weeks later, the judge changed his mind, and we never had the opportunity to try the case. But that just gives you some sense of how close we came, because we knew if we tried the case, Mona, we would have a very good chance. The Justice Department's position is indefensible if it's ever subjected to cross-examination. And as of today, it still never has been.
In the Second Circuit, we came very close in this sense. The court held our action in abeyance. They didn't issue a judgment right away. The panel, and it was a 2-1 split, said, you know what we're going to do is retain jurisdiction over this matter to give you the time to file a descheduling petition with DEA such that we can make sure they act with alacrity. And I guess one of the nuances people fail to recognize is that we are bound under Article 6 of the US Constitution by the treaties we enter into. And one of them is the Single Convention Against Narcotics of 1961. And so we're in this funny conundrum. You've already got Bahrain and China complaining about our sovereign territories, like little mini sovereigns, California and Washington, daring to enact recreational cannabis laws. So there's a global perspective to this. It's moderately complex, but the Second Circuit, I think, kind of missing this, as I say, nuance, did give us a framework that they thought would probably be beneficial to our efforts. The problem is we knew that those efforts would be stymied.
The judges even said we had such a huge audience that came to the Court of Appeals for the Second Circuit, and then they apologized to the next case that came up and said, sorry, there's just not as many people here interested in your case as they were in the last case. And one of the justices said, well, they were here for common sense.
Yep.
It was glorious.
Tell them, Lauren. Tell them. Yep.
Michael, you had mentioned before that you were looking into possibly bringing another legal challenge. Do you have any updates to share on that, or just anything else to share in terms of what's next for you?
Well, one thing's for sure, we're not going to stop simply because we did not succeed on this occasion. Brown versus Board of Education, Reed versus Reed, Lawrence versus Texas, those were not the first cases that changed the world. Brown versus Board of Education was the culmination of a series of civil rights lawsuits. Same with Reed versus Reed, which established gender equality. Same with Lawrence versus Texas, which conferred rights of gay Americans. Same with the marriage equality case. This was not the final case, but it was the one, I think, that really laid the groundwork for future litigations. We did, for example, obtain an acknowledgement by the courts that cannabis constitutes an effective treatment for disease. The Second Circuit, during oral argument, specifically actually stated that perhaps the court should take judicial notice of the fact that cannabis constitutes a medication for the treatment of disease. When a court takes judicial notice, what that means is that the issue is so obvious that there's no point in introducing evidence. So that's a pretty strong statement.
So much of this case centers on the sort of like federal state conflict in cannabis laws. And Leo, I was hoping you could tell us more about how that issue specifically impacts veterans.
So the VA currently, it's wild right now, because it's so much like, so the way it works right now is that if you are enrolled in a state medical marijuana program, then the VA isn't going to mess with you. But if you are, or if you're consuming cannabis and you're not enrolled in a VA program, then your benefits could come under review. Like they could take them away. The VA is probably the largest or the greatest single customer of the pharmaceutical industry right now. We're at 22 veteran suicides a day. It's 5 a week here in New Jersey. And so when you look at states who have comprehensive medical marijuana programs, they're starting to see a drop in the number of opioid abuse and addiction incidences. They're also seeing a drop in the number of prescriptions being written for those opioids. And that's because some states are using cannabis as a means to get people off of those opioids. The VA, very, very slow. And so it's because it's all federal. And so these are all things that, again, not only are we one of those like the Attorney General, we're also looking at who's going to be the Secretary of the VA as well. The former Secretary of the VA said that they would like to see some sort of, research and whatnot for cannabis legalization. I know Dr. Joy Beckerman is leading up a study on the efficacy for cannabis as opposed to how it works with veterans. A number of things are happening, but there's still that little bit of, put it like this, Mona, no matter what, state, federal, all roads, all the ills of the cannabis industry, all roads lead back to education or lack thereof. That's pretty much sums it all up. If this was a television show, the four of us are in season 8, episode 6. The federal government's still in season 1. Spoiler alert, it's not a gateway drug. That's the series finale of season 1.
Throughout this whole journey from the Southern District of New York up to the Supreme Court, what was a big challenge you guys faced in the course of this case? And what was sort of like an exciting or like a really positive, exciting moment for you?
When we had a judge in the Southern District, tell us that cannabis is medicine, to have that be reaffirmed in the Court of Appeals, that's never happened before, to have federal judges come right out and say that, we're largely right in our arguments. But what's frustrating is to still lose, notwithstanding being right. And we just feel like the court had the opportunity to do right by this case and by these issues. And notwithstanding how obvious the win was, to lose on procedural issues it stings. So I think that those to me are the highlights and, just sort of the disappointing aspects of the case.
I would say the biggest challenge in this case for me actually came at its very end. And that was when we found out that we didn't get cert at the Supreme Court. Because for me, when I opened up the screen, actually, I saw, and it said cert granted, and I scrolled down too quickly, and I saw our case. I don't think Joe and Lauren know this. I saw our case and thought we had gotten cert. I thought the Supreme Court accepted our case. And then I scrolled up carefully, and then I realized they'd only taken like 1 or 2 cases, and ours was in like a long list, as Joe said, hundreds of cases that weren't taken. And I have to admit, it was a hard day for me because I put a lot, and we all did. We all put a lot of time into this case, and I was incredibly disappointed. Perhaps naive that I thought we were going to get cert, notwithstanding the odds. But it was hard for me because I really felt that being right was enough, and it wasn't. Now, the following day, as Lauren will attest, I was already thinking about how we were going to fix this problem. And the answer I came to was, we should form this organization. We should say, you know what? You think we're wrong? The hell with you. We're right. And we're coming back stronger with more cases, with more arguments, with more plaintiffs, with more evidence. And we're going to win this. If we didn't win it this time, we'll win it next time. So when I think about the hardest thing to overcome, it was the bad news. But I know we have overcome it already because we're already organizing. And we are going to succeed one way or the other.
For me, I think there's 3 things. I think first and foremost, it's amazing. It's a remarkable feeling to share community with attorneys who do this kind of work and who are willing to actually go the mile and do that work, notwithstanding their law practices and their lives and the great tax and the time it takes for all of us. So I think it's remarkable to have that micro community. Then throughout this case, we came together as part of this really beautiful and powerful movement. And then the other takeaway for me is what we do resonates, the lawyers here do resonates with other young people who are becoming lawyers, right? And I've watched young lawyers move into the cannabis space now that are looking at what we do and want to talk to us about how we've done it, or, get a bite to eat with us. And there's a mentorship relationship that's going on. I had a kid reach out to me and say, I want to go to law school. I want to be like a lawyer like you. And if that's what we're doing, is helping actualize young people, and not even so young people, into being those kinds of socially just attorneys who can kind of pick up where we're leaving off. And we're, in a sense, also so privileged to be doing what we're doing. We're paying it forward ourselves to other people. But it's an extraordinarily beautiful feeling to have that at the end of the day, notwithstanding losing cert. It makes it all worthwhile.
Well, I just want to say that, Mona, I'm a soldier. I'm a veteran. I'm a soldier. And I have been built to be a protector of the realm. I want all things what's best for the realm. And when the blessing in this whole thing was, I know 3 other people who are just as hard-headed as I am, and to Mike's point, it seemed like it was just like the next day he was ready to go with something else, and I'm like ready to go with him. Nobody is standing pat. Nobody is down in the dumps and ooh, we lost. Nah, we all like, let's go, because we got some real work to do. So seeing these people, being joined at the hip with these folks, I just got some, bigger members of the family now, and I love them all for it.